Hello and welcome to Short
Circuit.
Yes, this is Short Circuit live at Denver Law, at Strum School of Law here in Denver, Colorado. We are recording this on April 8th, 2025, and we are very lucky to have a distinguished set of experts here to discuss qualified immunity. Now, for those listening on the podcast, you may be a bit familiar with qualified immunity if you've heard a few episodes of Short Circuit, but some of the students here are, I believe, as well. But for a very level setting, I'm going to give a quick definition of qualified immunity, but after that, we are going to turn to our panel of experts, who I first will introduce. Now, Colorado is a special place when it comes to qualified immunity because they are a state that has actually addressed the issue with legislation, which is not true in most states and is not true, unfortunately, at the federal level. With me to my right beside me here is Senator John Cooke. He is now retired, but he served in the state Senate for 8 years, and before that was county sheriff for 12 years and worked in law enforcement for 30 years. He was in the Senate when Colorado passed qualified immunity reforms in 2020. That is what was SB 2217, and he's going to discuss a little bit about how that sausage was made and how that reform happened, and then we're going to have a bit of a discussion about that. He's also a graduate of the University of Northern Colorado. Next, we're going to hear from Andy McNulty. Andy is a civil rights lawyer and here in Denver, Colorado. He's with the firm of Newman and McNulty. He's litigated all kinds of civil rights issues. We at IJ have partnered with him. We've done an amicus brief in one of his cases. He's also a graduate of Northwestern Pritzker School of Law in one of my favorite cities of Chicago. And then we have a hometown hero here, Professor Laurent Sacharoff. He is in his third year here at the Denver University, but before that, he taught at the University of Arkansas. He is a graduate of Columbia Law, and he clerked for the Honorable John S. Martin Jr. on the Southern District of New York. Maybe in the judges' chambers, it's not a sovereign. It's more of a DA thing.
Yeah, it's a U.S. attorney thing.
I see. Well, Article 3 and all that. Well, we will start with Senator Cooke, but just very briefly level set. Qualified immunity. You hear about qualified immunity a lot in the press, especially it became a big deal after the murder of George Floyd a few years ago. But essentially what qualified immunity is if you are suing a government official and you prove that they violated the Constitution, that is not necessarily enough for them to be liable for damages for having violated the Constitution, because that is only true if the law is, quote, clearly established. And so you have to overcome that the law it was so wrong, it was clearly establishedly wrong in order to overcome qualified immunity. There's a lot more to it than that, but that's the basic outline. Here in Colorado, there were these reforms passed where if you sue in state court under the state constitution, you do not have to worry about qualified immunity, and there is a cause of action to try to vindicate your rights. And Senator, how'd that all happen?
Well, it happened because of what you mentioned, George Floyd, what happened up in Minneapolis. And so legislators here said, well, okay, is that possible that that same type of thing could happen here in Colorado? And so some of the legislators wanted to come up with a comprehensive law enforcement reform package. And it turns out at the end, because what happens on a bill, what's introduced is totally different than what the final bill is. So they introduced a bill, and the final bill, though, was about 25 pages long, 19 different sections. And like I said, it was comprehensive. So there were, like I said, 19 sections. There was like 5 pages on body cams, reporting by agencies and Division of Criminal Justice. They had to report and put it on their websites. There was a section on revoking peace officer certification after a conviction, law enforcement response to protests. One of the sections was civil action for deprivation of rights. And of all things, that was 1 page. And that would addressed the qualified immunity and the good faith exception. But that was only 3 lines. And most of that section, which you all will be interested in, was concerning attorney fees. And then there was other sections about use of force and the power and duties of the AG and the post board to decertify. So it was, like I said, it was very comprehensive. The way it works is that legislators have very few original ideas. Just going to be honest on that. Most of what happens is like lobbyists or special interest groups will come to a legislator and say, we want you to do this. And they know who to go to legislation, to what legislator. Like I'm very pro Second Amendment, so the gun rights group would come to me. Very pro-business, so some of the business people would come to me. The people that wanted to do 217 were the ACLU, pretty far left groups, and wanted to really punish law enforcement. And so they actually wrote the bill. And one of the people, I think it was one of the people from the ACLU, admitted to me that, hey, we just threw everything up on the wall to see what would stick. And that's kind of pretty much what they did. They sat around and said, let's do this, let's do that, and see where it goes. And I always had a pretty good working relationship as a senator, and I'm a Republican, and so some of the things I might say might sound not biased, but partisan. And, the legislature is a partisan place. And so the Democrats wanted to have this comprehensive law enforcement reform bill. And so they sat in a room, let's see what all happens. And I had a good working relationship with all those groups, the Defense Bar, the Trial Lawyers Association, the ACLU. I had a good working relationship with them. I didn't agree with them on just about anything and vice versa, but we were able to work and talk together and maybe come to a common ground. And so when 217 came up, I don't believe we saw it until the day after it dropped, and it was going to committee right away. And I'm walking with the person from the ACLU, and I was pissed. The more I was reading this bill, the more upset and mad I got and I told her, I go, this is nothing but an F the police bill. That's all it is. And she goes, well, don't worry about it. It's going to change. It's going to change. We're going to work on it. And again, legislators don't write their own bills. The 2 bill sponsors in the Senate came to the committee, and what happens is you present your bill and you talk about it and you answer questions from the committee members. And I was on Judiciary. And so myself and Senator Bob Gardner, a Republican attorney from Colorado Springs, we started questioning the bill sponsors. And it was clear they had no idea what the bill said. After about an hour, and we were only on page 2, they had the chair said, okay, we're not going to have them take any more questions. We're just going to go to witnesses. And I think we went to like 1, 2 in the morning on this one bill. And so we started working with them. People came in and testified. And then what happens is it goes, if it passes committee, which it did, it went to the Senate chamber where we had second readings. But before that happened, the Senate sponsors came to me and Senator Gardner and said, work with us. This is not the bill we want, but you need to work with us to help us make it better. And at the time it was introduced, the county sheriffs of Colorado, the Police Chiefs Association, the DAs were all against it, as was the FOP, the Fraternal Order of Police. They were all against the bill. And we sat down with the bill sponsors and said, this is what we need to do. This is what you have to do. Because I was the only one in law enforcement at the Capitol, and in the Senate, Bob was the only attorney in the Senate. So we sat down with them for days to work on this bill with them. And one of the bills, or one of the sections, well, like I said, was qualified immunity. And that was a hill we were going to die on. Senator Gardner and I, not that we wanted to keep qualified immunity, we said, okay, you can get rid of qualified immunity here at the state level, but we're going to die on the good faith exception. So we were able to keep the good faith exception. And on second readings, I ran an amendment. The amendment was, I believe, number 89. And so there was well over 100 amendments to this bill that we're debating and arguing down on the Senate floor. And in the end, what happened was we were able to get just about all of our amendments in, and it passed out of the Senate on third readings 34-1. We only had one person vote no on it. It went to the House, started the whole process over again. The House had their committee. They put on a whole bunch of amendments, went to second readings, and then the House sponsors came to Bob and I and said, what do we do? What can we do? How do we make this better? And so we went through the whole process again with the House, which is very unusual. We don't work well together, the House and the Senate. We kind of look down on the House, and they kind of make fun of us. So working with the House sponsors was kind of unusual. And we got the bill, they got the bill to a good place, and it came back for third readings because when you have an argument between the House and the Senate, you have to go to conference committee and work things out. By the end of the time we did that, the Chiefs Association, the Sheriff's Association, and the DA's Association all supported the bill. And the FOP never did because of the qualified immunity. They said, well, if we're going to take away qualified immunity, we're not going to support the bill at all. But then on the second time it came back in the Senate, it passed 33-2. One other person kind of dropped off and voted against it. So that's kind of pretty much how the sausage gets made. Yeah. And we died, and like I said, we fought on the good faith exception, and we won that. So the good faith is still in the bill. And the reason, too, we kind of didn't really care about getting rid of qualified immunity. I could go either way. Either sometimes it's good. I think it has guardrails. And sometimes it's bad. But I think the courts were there to figure it out, and I think they did on these two cases that we're going to hear about in a minute. But the good faith exception was important to us because you have to have some protections for people that make mistakes. And Cameron over here, he and I sent some emails, and I'll just finish on this if that's all right, sent back emails back and forth, and he gave me his opinion of my amendment. And he was spot on, and this is what he said, because I told him about the good faith exception. And he said, as I read it, this was a reasonable change which aligns with the broader goals of balancing accountability for government officials while ensuring that they have the necessary protections to perform their duties effectively. By removing the blanket prohibition on good faith as a defense, the amendment avoids overly punitive consequences for officials who act within reasonable belief and their actions are lawful. At the same time, it maintains the elimination of qualified immunity, which responds to calls for greater transparency and accountability in cases of civil rights violations. And I couldn't have said it better. That was a perfect analysis of my amendment and what we changed on that section of the bill.
And I should add, that's our very generous sponsor, Cameron Westbrook, today. It's a 2L here at Strum School of Law for our event, which is sponsored by the Federal Society chapter here. So that was great. Thank you, Senator, for a little bit of sausage making there, which of course is typical of legislation, but what is not typical of reform in this area is usually it doesn't amount to a bill, and everyone was able to pass the bill in this case. Now, Andy, you were there in the trenches, maybe the other side of one of those trenches in this case. How do you remember things?
Yeah, I was one of the guys probably who the senator thought was writing an F the police bill. I like to call it a police accountability bill personally, but potato, potato, I guess. And yeah, it was a really interesting period. We tried to get this particular law, SB 217, passed in the previous session, and it failed. And then George Floyd was murdered. And then as we were passing this bill, I remember being in the House and the Senate, and you could hear the protesters outside chanting in the chamber. It was a really profound moment, I thought, and that's what propelled this forward. It was a moment when both sides of the aisle, I think, realized that there needed to be more police accountability in Colorado, and agreed on that, and that it ended up being a bill that was passed with pretty much bipartisan support after a bunch of back and forth.
Actually, and you're right. Maybe not tomato, but the way it was introduced, because the way it was introduced was totally different than the way it came out. And you're right in that law enforcement agencies were in support of the bill when it came out, because we were able to work together. The Republicans and the Democrats were able to work together, and what I say, fix the bill. And so it was more of a police accountability, which I was all for. And most sheriffs and police chiefs are for more accountability because, well, sheriffs are for it because they want to get reelected. And police chiefs want to keep their job because they respond to, or they report to a mayor or city council. So chiefs and sheriffs do want police accountability because it's transparency, and we have to show that to our public.
Yeah.
Andy, I'm curious. So it's now been 5 years almost since the bill was passed. I think 4 years since it went into effect. Have you seen changes in civil rights? So what this means now is you can sue under the Colorado Constitution for a civil rights violation and not have to worry about qualified immunity. Is there been a change amongst the bar? Have you noticed? Have your cases, have you approached them differently because of this?
Definitely. I think that there has been a shift in the mindset of whether you'd go to state or federal court to sue for these things. Before, state court wasn't even an option, right? And now it is. And also the Colorado Constitution is uniquely Western. It's uniquely Colorado. It's more protective of rights than the federal Constitution is. So rights that maybe you had as a Coloradan you couldn't enforce before, but now you can under this law. So it's changed that practice. And then it's also, we're going to talk about, I think, a couple cases here where someone had their rights violated, but they had their case dismissed because it wasn't clearly established. So now lawyers are looking to see, hey, we know that this is a constitutional violation. It might be even super egregious, but there's no case on point. So we need to bring it in Colorado courts under this new law because otherwise it might get dismissed because of qualified immunity.
Right. Well, let's move to one of those cases. So I asked Andy what case would you like to do, and it's actually a case he litigated, and it didn't come out his client's way at the 10th Circuit, but he litigated it a few years ago. It is Surratt versus Clamser, and it raises this thing we talk about with qualified immunity all the time, which is what level of generality to define your right and what level of generality to define the case law that defines what a clearly established right is.
Yeah, this is, you have some of those cases throughout your career where you're just like, man, and you shake your head because you feel like it's a miscarriage of justice. And this is one of those for me. So I want to talk about it here because what better case to talk about qualified immunity than a case where your client was severely wronged and nothing happened at the end of the day to the officer. My client was a young woman. Her name was Michaela Surratt. She was out for her 22nd birthday at a bar in Old Town, Fort Collins, with her boyfriend and a bunch of their friends. Her boyfriend got kicked out of the bar for I don't know what reason, but I'm sure it's 22-year-old reasons, of course. And so she went out to go find him. He's standing outside and he's talking to a police officer. She did not want him to continue talking to that police officer, so she approached the officer and was trying to get him to leave. And he was like, no, I'm going to stay. Another officer came up and said, no, you can't talk to your boyfriend right now. And she was not happy with that. And so she was like, no, we're just going to leave. We're just going to leave. And the officer said, no, you're going to stay right here, grabbed her arm. And at that moment, she was not excited about that either. So she started to pull away from him and tried to kind of pull his hand off of her arm. And he was not excited about that. And so he grabbed her and slammed her face first into the concrete, gave her a concussion, sprained her spine, and really messed her up. This video went viral, so you could look it up after this. If you Google Michaela Surratt barstool, unfortunately, that's what comes up. And you can see this video of her being slammed face first into the ground. So we brought this case on Michaela's behalf because obviously, excessive force. This is not something you can do if you're an officer. Someone is minimally resisting, they're just pulling away, and you slam them face first into the ground. It doesn't seem like a rational use of force, and it would be excessive under the law, under our opinion, and under the opinion of the courts ultimately too. A couple other things you need to know about Michaela too is she's very tiny. She's about 100 pounds. This officer was 6'4", about 220 pounds, so a big guy, and he just manhandled her. So we bring this case, we litigate it, we get all the way to summary judgment, we win on summary judgment, we're gonna go to trial, and they end up appealing it to the 10th Circuit Court of Appeals on the basis of qualified immunity. The lower court said that, we found there was a constitutional violation here, and then also that the law was clearly established, that you can't just slam someone to the ground face first, give them a concussion, simply because they pull away from you. And so the city and the officer appealed to the 10th Circuit. We filed what's called a motion to certify the appeal as frivolous. This is a rare procedure in the district court. We filed it. The court granted it and said, yes, this appeal is frivolous, certified the appeal as frivolous. That still doesn't take away jurisdiction from the 10th Circuit. It's a weird thing in the law. The 10th Circuit was still like, nah, we don't really care what the district court says.
I think of it as a red flag, at least.
There should be a red flag there, yes. The red flag was blown through by the 10th Circuit. We get up to the 10th Circuit, and the 10th Circuit says, yeah, you know what? This is a violation of your client's constitutional rights. This was excessive force, but not clearly established. There's a case in the 10th Circuit that says if you use force like this against someone who's not resisting, then that's unconstitutional. But she was resisting a little bit, so that's distinguished. There's cases from other circuits where, and a bunch of other circuits where it says that if someone is resisting a little bit and you use force on them, then that's unconstitutional. But those other circuit cases, they're not exactly the same as this case, so not good enough. There's unpublished cases in this circuit that say what happened here is unconstitutional. But as you know, when we don't publish the case, it doesn't count. So, it's not clearly established. And this wasn't egregious enough. It went viral. Everyone was in outrage across the country, but just not egregious enough to be a violation of clearly established law. So our case was dismissed against the officer, unfortunately. We lost that claim. We ended up settling with the city because qualified immunity doesn't defeat claims against the city, only against individual officers, but for significantly less than her claims were worth, I thought, if we had the officer involved. And so at the end of the day, it was just really one of those frustrating cases, and I think a real illustration of the dangers of qualified immunity for officers who I think anyone would see what this officer did and would say that was wrong, but the law didn't say that.
Professor Sacharoff, in some ways this is going to align with the case you have coming up, but what are your takeaways from Andy's?
Yeah, well, one of them is that in my case, which I'll get to, but on a particular point, the government cited an unpublished 10th Circuit opinion and relied heavily on it to show that the law was not clearly established. So it's interesting that not only the government, but the court was arguing that unpublished cases can't count. Are they right? I mean, is there binding precedent that unpublished cases don't count?
Yeah, for qualified immunity purposes, there is. Yeah. So, I mean, the thing too is in 2025, right? Unpublished versus published is such a meaningless distinction. Every case is published on Lexis or Westlaw. The other thing to think about is, are these officers sitting down and reading every single decision that comes out? I just don't think it's true. I think that they get trained on Graham. I think they get trained on the big cases, but they're not reading Morris versus No, which is the case that the court in our case said wasn't good enough. They're not reading those in-depth cases, and a lot of lawyers aren't until they get the case that they need to read it, right? So I think it's just it's kind of a meaningless distinction nowadays about published versus unpublished, and then thinking that officers read these cases on a daily basis.
Well, this is a good opportunity to tell everyone, remind our listeners that we have a sister podcast called Unpublished Opinions, where, amongst other things, sometimes we gripe about unpublished opinions because it doesn't make a lot of sense to me. I know judges like them because sometimes the more routine stuff you just don't have time for, so you don't spend the time on that, and you don't circulate it maybe to the entire en banc court like they do published ones. Like, I get that, but still, it's law and it should be treated as law. That's my opinion anyway. Senator Cooke, your thoughts?
Thank you. Yeah, you're right. Officers don't sit down and read these kind of cases. We do have, at least at Weld County, we had legal updates training, but those mostly consider like, what did the state legislature pass to do to us now, kind of a thing. So we would sit down and we'd have our county attorney or the district attorney go through the new laws that were like passed in the state. But as far as when it came to federal cases, no, these published decisions. And, one of the biggest issues with 217 with law enforcement was, the qualified immunity that we're going to lose officers, or, that's going to hurt us. But the thing was, it's like you said, it applies to state court. It didn't apply in federal court. And I don't blame the line officers for not knowing what qualified immunity is because they've heard about it. Oh, if you do something wrong, you get qualified immunity. So they go in to federal court. The county attorney says, oh, don't worry, we're going to fight this on qualified immunity. And that's all they know about it. So you're right, they don't sit down and read these kind of published or unpublished decisions.
One interesting thing about your case for a silver lining, I guess, is that the court did actually address whether her rights were violated and said, yes, jolly well right they were, but then went on to how it's not clearly established. And of course, federal courts have been told by the Supreme Court they don't have to do that. They can say, well, even assuming blah, 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 it's not clearly established. Is that, do you know if the 10th Circuit is maybe better at that, at addressing, so at least it's a clearly established for the future than other circuits, or how it normally works here?
I think this court's decision was the exception rather than the rule, I'd say. Yeah, and you're right, it is great that they did this, because I've talked to 2 lawyers since that case is handed down, and now they're bringing lawsuits because of this, and I've said, hey, listen, now it's clearly established that if your client's minimally resisting and they get, really messed up by the police with excessive force, you can sue. And so they now are relying on this case. It's been precedent setting. And so it is a silver lining in that sense.
Well, I guess you didn't need a silver lining for the plaintiff in the next case, because although it went up on qualified immunity, it was held to be clearly established. And this is a Lusci. Apologies to the plaintiff, but I'm not pronouncing his name right, versus Kyle. Now, this is a recent case. It came out March 19th, 2025, also from the 10th Circuit, and Professor Sacharoff's going to tell us about it.
Yeah, great. This is a published decision, and as we've been discussing for qualified immunity, the facts really matter. Often they'll compare the facts of this case almost fact for fact to find if there's some previous case where almost are the plaintiff's names the same. Like, that's how close sometimes they get.
Not quite as bad as the Bivens doctrine, if your name is Webster Bivens, but close to that.
Yeah, and so critics of qualified immunity will often say that the problem with the doctrine is if the facts aren't almost exactly the same, that qualified immunity is available and the law is not clearly established. But this case is a great case because it's a counterexample, and maybe a new trend, maybe not. But let me go into the facts because they are so important. And so this was February of 2022, and it was in the evening, and it was dark, around 6:40, and a 911 call came in, and the 911 caller said that some man had broken the outside window of their neighbor's house, and then fled. That was the 911 call. The officers arrive to the place where the window was broken and see that the window is a little bit broken. The screen is still there, though, the screen behind the window, and the officers decide that they need to do a search of the interior of the house. They finish breaking the window, they remove the screen, they don't announce themselves, they don't say anything, they certainly don't get a warrant. But what they do have is a dog named Sig, S-I-G, and the officers, or the officer who's the handler, which is Travis Kyle, the handler of Sig, instructs Sig to enter the house and bite, meaning arrest, or arrest meaning bite, the first person that Sig encounters. Now, you might be thinking, you're making that up. How can you make an order to a dog like that complicated? But to quote the court, Mr. Kyle ordered Sig to, quote, find and bite whomever it found inside the residence, and then elsewhere it says, meaning the first person that it encounters, whether it's a child or an adult. And the court also said whether or not they're lawfully at the residence. Now, I don't know if that was part of the instruction to Sig or just an editorial comment by the court, but apparently handlers can order their dogs to do somewhat sophisticated tasks, including biting the first person they encounter. All right, so that's maybe not that sophisticated, but in any event, they drop the dog into the house via this now open window, and the dog goes in and bites the first person it encountered, who turned out to be the plaintiff, Mr. Tyler Luthgy, who's asleep in bed. So he's asleep in bed, he lives there, it's his house, and the dog bites him and grabs his arm with his mouth, with his teeth, and holds on to him. And it was later described as throwing him around like a rag doll. So the officers come into the bedroom. Luthgy is on the bed being torn around by this dog, yelling. Well, what do you think he's yelling? "I live here, I live here, I live here," to quote the court. The officers do not say, "Sig, down boy," or whatever the command is, or maybe a sophisticated command, "cease the arrest and come here." Instead, they allow the dog to continue to bite and throw him around while they question him for a full minute about, what do you really live here, etc. Okay, so finally the dog releases him. They nevertheless arrest him, bring him outside. He's bleeding and in pain, and his arm is numb, and they eventually...
And no shirt on, right? Just PJ bottoms, I think.
Yeah, oh, I missed that fact. Okay, thank you for that. You see, it just gets worse and worse. Now, if the earlier case did not involve pajama bottoms, sometimes we'd be out of luck. But, and so he is then arrested. Only when they're outside do they manage to look at his driver's license to see that he, in fact, lives there. Okay, so he sues for under Section 1983, a civil lawsuit for damages, seeking account for unlawful entry and search of the house in the first place, unlawful arrest, no probable cause to believe he committed a crime, and then finally, use of excessive force. I'll talk about the use of excessive force, but for all three, the district court and the 10th Circuit found there was a constitutional violation. And for all three, the police raised qualified immunity, saying even if there's a constitutional violation, it's not clearly established that we can't enter under these circumstances. It's not clearly established that we can't arrest somebody under these circumstances. And it's not clearly established, the one I'll talk about, that this was not excessive force. And so the court held, first, there is a constitutional violation. It was excessive force because, and then it used the 3 Graham factors. And the 3 Graham factors from the U.S. Supreme Court on excessive force are whether it's, how serious is the crime? Was the person resisting, and are the officers in danger? And it admitted that burglary could have been the crime, so maybe it's a serious crime. But the main factor was, in no way is he resisting, in no way is there imminent danger to the police, because he's in his house. So for the excessive force, it's pretty clear that using a dog to bite somebody you don't know who, you don't even know if they're supposedly the person who broke the window, is excessive force. But when we come to qualified immunity, that's when we have to start looking at, is there a similar case? Now, I would have thought, I'm paranoid or something, but I always think the worst of courts and on qualified immunity, and that they're always going to say, yes, there's qualified immunity unless there's the same situation. And the same situation I would have expected is you need a case with a dog in which the dog went into the house and bit, even though the officers weren't there. But what is surprising about this 10th Circuit case, which I like, is that the court was willing to act on a much higher level of generality, meaning it couldn't find any dog cases that involved excessive force pre-arrest, like before the police themselves even got in there. It found a dog case for post-restraint, it called, but there was no case for pre-restraint. No dog case, not even a case that's similar. Nevertheless, it said that it was clearly established that doing this was unconstitutional, and it cited Graham itself. And by citing Graham itself, it's basically saying the same inquiry for whether there's a constitutional violation is practically the inquiry for qualified immunity. Meaning, if someone's not resisting and you're not in imminent danger, it's excessive force. Well, that's just the Graham case. That's just whether there's a constitutional violation. So the 10th Circuit almost collapsed those two inquiries, which is interesting. And then the other case it used was a taser in which the police tased somebody when it was unnecessary. But again, that really just went back to the idea that if somebody's not resisting and you're not in danger, it's excessive force. How did the court end up doing that? I'll just finish with a sort of the legal principle that they recited, which was a little bit different from what you often see. So when the court said, we need to find an earlier case that's on point that shows it's clearly established, they also said that on point can mean not just that there's similar conduct in the earlier case, but the earlier case applies with obvious clarity, meaning a general statement of the law can be enough, and it's not a scavenger hunt for prior cases with precisely the same facts. So when you put together the statement that a general statement of the law can be enough with how it did it here, and also with the other counts, I think it's a positive development for qualified immunity, basically and it's a real contrast with the Surratt case, because I think if this panel had been deciding the Surratt case, they would have said, yeah, general principles of excessive force from someone who weighs 100 pounds and is clearly not resisting in any way that matters is clearly established. So I'm happy about the case.
So Senator Cooke, you were saying in the green room earlier that worked in law enforcement for 30 years, but these would not have been officers you would have been proud of.
No, not at all. I mean, the court, the circuit court, the appeals court, they don't look at things in 20/20 hindsight. Because things happen so quickly in law enforcement. So you might get to a scene and you might have a split second to make a decision. So the court looks at things based on what the officer might be presented with. But reading this case, it was bad from the beginning. To not announce yourself just because you have a broken window. You could have put a deputy in the back of the house and set up a perimeter if you really thought there was a burglary going on. And I think that's what they were thinking. There must have been a burglary. But there's a lot of different things they could have done. Announce, try to wake the guy up, call the residents, see if somebody's in there before sending the dog in just to bite the first person they see. So, it was bad from the very beginning. And I had 8 K-9 officers at Weld County, and they would no longer be a deputy, really, if this happened up there. And I'm not saying anything, because I wasn't there. So I'm just going off of what the 10th Circuit or the appeals court said, and that the facts are pretty bad. And they wouldn't be working for me if those same facts occurred in Weld County.
Yeah, I'll just say one thing procedurally, which was that this was on a motion to dismiss, not summary judgment motion. So the facts are completely one-sided, completely the facts of the plaintiff. So to make you feel better about your former colleagues, if there is if we get to summary judgment and there's no settlement, it may be that the facts are much more complicated and that there are more positive facts for the officers.
And there's no mention of body cams, I saw, and maybe that there just weren't any, but maybe they haven't been introduced at this point, which probably means they're not very good, I have to say, because often on motion to dismiss, right, if it's mentioned in the complaint, the defendant will try and introduce that because it gives a more full story than a.
Well, that's what they did with the
does.
911 calls.
Right.
And 217 required every law enforcement agency in the state, local and state officers, to have body cams, and I believe it was by 2023. Is that correct? So they were required to have it, and I'm not sure when this case happened.
2022, February 2022.
Oh, okay, so it was a year before it took effect to have body cameras.
Interesting.
I have to say, as a practitioner, this case is one that really, I mean, it just frustrates you, right? Because you don't know what the test is now, right? In some way, it's a great case, right? But I've had 10 other cases that have been dismissed on qualified immunity that have had, I feel like, obvious facts, and the 10th Circuit hasn't collapsed the test like this, like they have here. And so it just creates this climate where you don't really know what is going to be clearly established at the end of the day, because you draw one panel and it's one way, and you draw another panel, it's a different way, and that's not the way the law should be.
Yeah, absolutely. Do you think that this is any reason this might be en banc worthy in the 10th Circuit, or just kind of add it to the pile and we'll see what keeps coming out?
I mean, it could be one of the 2 cases that they take en banc per year. They don't take many in this circuit. It's very, very limited. So I would be surprised if it went en banc. Yeah.
Yeah, I mean, they might be wise. I mean, the 10th Circuit pointed out that motion to dismiss is a bad posture for the government. So they might decide, let's go back and wait for summary judgment and get some of those better facts in first before we make really bad law.
Right. So earlier this morning, I was talking with Professor Sacharoff and some others about the 10th Circuit. And so some listeners will remember this. We had a competition about 3-4 years ago about the most beautiful courtroom in the United States in a federal appellate court. And we had a lot of readers write in with suggestions. I think we did a poll on Twitter, which it still was back then, about who the winner was. Anyway, the Fifth Circuit en banc courtroom was high up there. There were a couple on the Ninth Circuit. The one in one of the ones in Sacramento, I think it is, and then the Portland's historic courthouse. A lot of people liked, but the winner of all of them was the library courtroom at the 10th Circuit here in Denver. Have you ever argued in there?
It was my first oral argument ever.
Oh, my goodness.
And the 10th Circuit was in that courtroom, and I'll tell you, it's a little intimidating. You're surrounded by all these books, all these learned folks, and you're up there trying to make your case. It's tough.
So one question I've always had about that courtroom, because it's full of but I don't think they're the fancy, but I think they're federal reporters or something. But it's full of books. Is it kind of like take the sound? There's not a lot of echo because the sound goes into the books.
Oh yeah, it's dead silent, and you're up there talking, and you're wondering, am I saying something that's insanely stupid? It's not a good environment for someone who's up there for the first time. I'll tell you that.
A little intimidating.
Yeah.
Well, great. Well, I'd like to thank the panel for coming today for Short Circuit. I'd like to thank the students here at the Strum School of Law for coming to this live recording, and also thank the local Federal Society chapter for inviting us. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all the other podcast platforms. And remember to get engaged.